There's a thing on Michael Proctor. Unfortunately, I didn't know it was 7 hours. I'm just gonna give y'all basically a recap of it, and after the recap, I'm gonna go on about my business. Uh, 1 second, 1 second. And day two is tomorrow morning.
It's time, your time, not just to go back to school, but to come back and move forward with Purdue Global. Start your comeback today.
And I'm also gonna try to come back with an overview of the Corey B case tonight as well. So it's gonna be a busy rest of the week for me. Stay ready. Okay, let me skip along. Oh, this audio is terrible. Let me see if I can find something else. Let me go to Boston 25, see what they got. Cause this audio, I hate this audio.
What would you say to somebody that hasn't tried therapy before?
Just ask yourself if what you're doing in your life right now is.
Okay, here we go. Just here's got better audio. And this is Boston 25 News. And we are going to be cherry picking through this.
A.m. on August 26, 2025. The first day of hearing is being held in person at the offices of the Civil Service Commission at 100 Cambridge Street in Boston, Massachusetts. Additional days of hearing are scheduled for tomorrow, August 27, 2025, and later this year on October 21st, 22nd, and 23rd. I am the hearing officer for today's appeal, filed with the Civil Service Commission on March 27, 2025, and docketed as case number 25-085. The appellant in this matter is Michael D. Proctor, Proctor. At this time, I ask that co-counsel for Mr. Proctor please stay seated, introduce yourselves, and spell your names for the record.
Good
very much, Mr. Moynihan, Mr. Russell, and Mr. Green. The respondent in this matter is the Massachusetts Department of State Police. At this time, I ask that counsel for the department again, please stay seated, introduce yourselves, and spell your name for the record.
Good morning, Commissioner Connie, Secretary Clinton, and Stephen Carley on behalf of respondent to the Department of Massachusetts State Police. It's called SDPANCAR-WY, Brooklyn is my associate, and one
Thank you very much, Mr. Carley and Ms. Rottenberg. This appeal was filed by the appellant pursuant to the provisions of Section 13 of Chapter 22C, which applies to state police disciplinary matters, and Sections 41 through 45 of Chapter 31, known as the Civil Service Law. The appellant is contesting the department's decision to terminate his employment as a state trooper. Under the applicable law, the burden is on the Department of State Police to show by a preponderance of the evidence that the appellant engaged in misconduct that warrants discipline. If the state police meets that burden, then the burden shifts to the appellant to show why termination, as opposed to a lesser penalty, was not the appropriate level of discipline.
Basically, ladies and gentlemen, this is nothing more than Michael Proctor trying to get his job back. That's basically all this is.
This hearing is conducted in accordance with the standard adjudicatory rules of practice and procedure, 801 CMR 1.01, formal rules. The provisions of Chapter 31 taking precedence over any conflicting rules. To ensure clarity, this is not a jury trial. This is an administrative hearing being conducted by a hearing officer. As such, it is my responsibility to make rulings on the admissibility of evidence and then determine what weight, if any, that evidence deserves, and to make credibility assessments as necessary regarding the witnesses that appear before me. Pursuant to Section 43 of Chapter 31, the Commission has deemed this a public hearing while reserving the right to close portions of the hearing if warranted. Members of the public are present in the courtroom today, as well as an adjacent overflow room where the hearing can be viewed live. The media has been permitted to set up a pool camera for audio, video, broadcasting, and recording. Prior to the hearing, the media and public have been provided with a summary of hearing room protocols that must be adhered to at all times. This hearing is also being audio and video recorded by the Commission via the WebEx platform. A court reporter is also present to transcribe the hearings, and that transcription will be the official record of this hearing. At the conclusion of this proceeding later this year, the parties will be given the opportunity to submit post-hearing briefs, at which time the record will close. Any final decision issued by the Commission regarding this appeal will be sent to the parties via email only. The Commission's decision will also be published on the Commission's public website at mass.gov/CSC. All final adjudicatory decisions of the Commission are subject to judicial appeal under Chapter 13A of the General Laws. Before we begin, a few housekeeping matters. First, in a final ruling sent to the parties yesterday, and after considering the objections of both parties, I have entered into evidence 36 exhibits from the Department of State Police and 58 exhibits from the appellant. As those exhibits have already been entered into evidence, there is no need to request that they be entered prior to referencing them at today's hearing. Second, I accepted the department's participant list, indicating that the department at this time has only one witness, and we will hear from him shortly. The department has committed to completing direct examination of this witness today. it is the Commission's expectation that the appellant will complete cross-examination tomorrow with the option of recalling this witness in October if necessary. I urge counsel for both parties to use your time wisely and make adjustments accordingly as the day goes on to ensure conformance with time allocations. Third, I hereby order the sequestration of witnesses. Any individual who is a potential witness in this matter may not attend or view any part of this proceeding until the conclusion of their testimony. Fourth, counsel for both parties have been allotted 15 minutes for opening statements. Since the audio is being captured by the table microphones, I'm asking counsel as well as witnesses to please stay seated while speaking, to speak loudly and clearly, and avoid any crosstalk. Please allow questions to be completed before objecting. At this time, I ask that counsel for the Department of State Police proceed with an opening statement, to be followed by an opening statement by counsel for the appellant. I will ask Mr. Quinnen to please keep the time.
Commissioner may I just make a statement for the record? Procedure.
Is this something separate from the motions that I announced yesterday?
No. Yes, it is. Yes.
Can this wait until after openings?
It can. It concerns the sequestration of it.
If anyone is going to testify, or you think they really should be in this room?
No, the difficulty is the fact that we're here at the request of the commission to start this process today, despite the fact that we're awaiting discovery from the department, as you know, and we don't know who all our witnesses.
Yes, if I'm speaking, don't speak.
Sorry.
That's quite simple. First of all, just for decorum. If you have anyone who is a potential witness, they should not be in this room. That's all I can say.
And because we don't have a discovery, we don't know at this point who all of our witnesses are.
I can't advise you how
other
to
than-
conduct your case.
I'm sorry.
I can't advise you how to conduct your case. Mr. Carly, can you please proceed?
Thank you,
Again,
Commissioner
ladies
McCartney
and gentlemen,
and Attorney Quinnen.
ladies and gentlemen, this is basically disgrace state police investigator Michael Proctor basically begging for his job back. That's what we're listening to.
Distasteful, unprofessional, inappropriate,
Very,
in poor taste,
very much in poor taste.
juvenile,
Yep, that it was juvenile.
sexist,
Show hell was.
disgusting,
That too.
dehumanizing.
Yep.
This selection of words does not come from a public comment section on a website, an op-ed columnist, or a protester outside the Norfolk County Courthouse. No, indeed, one would be forgiven for not immediately recognizing that these words are Michael Proctor's accounting of his own conduct in this case. Conduct in which Michael Proctor, tasked with the immense responsibility of acting as case officer for the investigation into the death of John O'Keefe, consumed alcohol and then operated his cruiser while on duty, released confidential information to individuals outside law enforcement, and called suspect and eventual defendant Karen Reed a babe, a nutbag, retarded, a whack job. She's got a leaky balloon knot, leaks poo. A woman who shits herself with no ass. She's fucked. A cunt. As a result, the department brought forward 4 separate specifications within 2 types of charges for internal discipline. And in March, Colonel Noble terminated Michael Proctor's employment. In support of the just cause for doing so, beginning today, the department presents for your consideration its evidence of the appellant's guilt under the charges and specifications described as follows. Charge 1, Specification 1, unsatisfactory performance, sending derogatory, defamatory, disparaging, and inappropriate text messages about a suspect. Charge 1, Specification 2, unsatisfactory performance, provision of sensitive and confidential information about a homicide victim, potential witnesses, and potential investigative steps to non-law enforcement personnel. Charge 1, Specification 3, unsatisfactory performance, through unprofessional and inappropriate conduct, created an image that he was biased and brought himself and Massachusetts State Police into disrepute. And finally, Charge 2, Specification 1, consumption of alcoholic beverages while eating dinner on duty and then operating his department-issued cruiser. The department's defense of the just cause of the adverse employment action against Michael Proctor will be based entirely upon the evidence of his conduct, his violations of those specifications under our Article 5. To prove this case here in this de novo proceeding, the department will call OPIA Detective Lieutenant Kevin Dwyer, who was assigned an investigation initiated by DIS Commander Lieutenant Colonel Brian Connors. In addition to the testimony of Detective Lieutenant Dwyer, the department has submitted and has been entered into evidence for your review and consideration of those 36 exhibits, demonstrating by a preponderance of the evidence that Colonel Noble had just cause to terminate Michael Proctor's employment. You will hear of Detective Lieutenant Dwyer's collection and assessment of the records of the appellant's misconduct, first brought to light in excruciating detail during 2 days of his public testimony at the homicide trial in Norfolk Superior Court on June 10th and 12th, 2024. You'll have the opportunity to hear the appellant read in his own voice his vile, misogynistic statements against the woman accused of and tried for the death of Officer O'Keefe. You'll have the opportunity to hear his revelations to high school friends and members of his family of the identity of the victim, his views on and details of the crime, the manner of the victim's death, witnesses to be interviewed, and the direction of that investigation, some made under 24 hours of the discovery of Officer O'Keefe's body. You will hear his own characterizations of his conduct that I quoted to you before. And you will hear his admissions under Charge 2 that while he was on duty, he consumed 1 or 2 beers with an officer from Canton Police and drove the 2 of them home. You will be given, in addition to the video recordings of that public testimony, transcripts of the appellant's own words for your review and reference, a summary of Detective Lieutenant Dwyer of his misconduct, of Michael Proctor's misconduct as revealed during the trial, pay station, administrative duty roster, and AVL data collected by Detective Lieutenant Dwyer corroborating the appellant's account of his alcohol consumption while on duty, statements and admissions by the appellant at his OPIA interview, and Detective Lieutenant Dwyer's conclusions therefrom, as well as the criminal trial exhibits themselves containing the appellant's messages. You will also have available for your consideration the findings and resulting recommendation of the department's internal trial board, as well as the limited selection of public reaction to the revelations of the appellant's behavior. Relevant portions of an interview he gave to ABC News following his termination, and an order from the Norfolk County District Attorney's Office for him to turn over as discoverable statements in a criminal prosecution under Rule 14 the content of his communications from his personal cell phone. The department expects that much by way of distraction will also be on offer in the days to come in the form of dubious and flimsy comparisons, whataboutisms reflecting the choices of others, spurious emotional appeals to the absolutely real difficulties experienced by members assigned to a homicide investigation, and insinuations that written statements by a case officer regarding his own investigation are somehow private or out of bounds. In short, the department expects an appeal not based on the truth, but on evading accountability. The department respectfully asks that this commission, while receiving those distractions or attempts at saying, keep in mind the evidence and the facts that are the basis for the department's case, it respectfully asks you to bear in mind that no one committed the acts for which he was terminated other than Michael Proctor alone. No one authorized his communications of sensitive, confidential case information about an active homicide investigation to others outside of law enforcement. No one forced or cajoled or even requested him to engage in such gratuitous behavior. And that Michael Proctor himself has admitted, as evidently he must, that his conduct was unprofessional, inappropriate, juvenile, sexist, disgusting, and dehumanizing. And that he has admitted that he in fact committed the acts exactly as described in the charges brought against him. Accordingly, at the conclusion of this hearing, the department expects to meet its burden, showing just cause, and will therefore ask this commission to uphold the termination of Michael Proctor. Thank you.
Good morning, Commissioner McCarthy. We're here today to hear evidence presented by the Department of State Police, which it believes amounts to just cause for the termination of Michael Proctor. Due to the fact that we continue to await discovery from the department, you will not hear a presentation of evidence by Michael Proctor today or tomorrow. You won't hear about his presentation of evidence until October. Nevertheless, we will, through cross-examination, get to the truth behind this case. And the truth is that as of February 1st, 2024, Michael Proctor was an exemplary member of the Mass State Police. He had served in that capacity for 12 solid years without any discipline. He had risen to the level of the ranks of detective for the Norfolk County DA's office as a young trooper, and served in the role as detective, and was a very well-respected member of that unit. As of January 29th of 22, Michael Proctor, a fairly new detective in the DA's office, was asked to become the case officer on the Karen Reed case. You will hear what his duties were as case officer, and you will hear all that he was not responsible for as case officer in this case. Now, as we all know, Karen Reed was arrested. She was indicted by a grand jury, and she was tried twice by the Norfolk County DA's office from 2022 through 2024. In the early part of late 2023 or early 24, the defense in the Karen Reed case convinced the U.S. Attorney's Office to open an investigation into a theory of a grand conspiracy against Ms. Reed on the part of law enforcement and others. You will hear that Michael Proctor was asked to testify in the federal grand jury proceeding as a witness only on February 1st, 2024. And when he appeared, he was shocked to discover that the U.S. Attorney had somehow infiltrated his personal cell phone and surreptitiously obtained personal text messages on his personal cell phone. Now, we all have personal cell phones. We all have expectations of privacy on those personal cell phones. On February 1st, 24, Michael Proctor suddenly found in his mind that his privacy was violated. Since the disclosure of these text messages, the world has changed. Law enforcement officers and people in all walks of life now shudder at the thought that a federal agency could infiltrate their personal phone and look at text messages, personal text messages on a personal phone to family members and friends. Michael Proctor has reacted to this unlike many other people would. Michael Proctor has never denied the authenticity of these text messages. He's never denied that they are inappropriate, unprofessional, derogatory, sexist, misogynistic. Despite the fact that he's never, to this day, received the full text threads numbering hundreds of thousands of dollars that the U.S. Attorney's Office obtained. And despite the fact that he still doesn't know why his personal cell phone was infiltrated. Michael has repeatedly apologized for making crude remarks, unprofessional remarks, juvenile remarks. We can come up with many other adjectives that Michael has admitted to. He has never backed away from apologizing for these outright unprofessional and, I'll call them stupid, text messages on his personal cell phone spoken to his buddies from childhood. Instead of backing away, what did Michael Proctor do? Well, the next day, he self-reported this information to his bosses at the Mass State Police. He reported the full context of these text messages to the Mass State Police, despite the fact that there's no existing Mass State policy concerning a trooper's personal text messages or personal private conversations on a personal cell phone. He reported it immediately. From that point, you'll hear evidence of what happened next and what didn't happen next in the ensuing 5 months and up to March of 25 when Michael was terminated by the department. You will hear of a meeting which was initiated by Michael and his then counsel on February 1st of 24, February 8th of 24, I'm sorry, wherein the content of these text messages was disclosed to the legal staff of the Mass State Police, as well as high-ranking members of the Mass State Police. You will hear that the Mass State Police assured Michael Proctor that not much would come of this, and that he may receive a letter of counseling as a result, or a written reprimand, and that the colonel and the command staff expressed appreciation for him immediately reporting these text messages to them. You'll hear of a separate investigation done by the department in April of 24, wherein the nature of Michael's relationships, alleged relationships with witnesses was investigated, and the issue of bias was investigated, and their findings were negative. You will hear that Michael Proctor remained on full duty from February 2nd, when he first disclosed, until July 1st, which is coincidentally the date of the Karen Reed mistrial. You'll hear that after that mistrial, that unfortunate date for Michael Proctor, July 1st of 24, the witch hunt for Michael Proctor began. He was relieved of duty within hours after that mistrial. You'll hear a press release from the colonel at the time who stated, quote, "Upon learning today's result, Michael Proctor was relieved of duty." You'll hear of intense political scrutiny, intense media pressure to fire Michael Proctor. You'll hear that this termination was not based on actual facts and evidence. Instead, it was a decision made to appease politicians and to appease some vocal members of the public and the media. You'll hear of the so-called internal trial board process of the Mass State Police and how flawed that process is, how unfair it is, and lacking in due process. You'll hear that despite the flawed process of that internal trial board, this decision to fire Mike Proctor was made on July 1st of 24, within hours after that mistrial. Most important, you'll hear evidence from the trial board in this hearing that Michael Proctor's personal feelings did not influence the evidence in the Reed case. Michael Proctor did not act with the intent to affect the outcome of this investigation. You'll hear that there's no evidence to show that the integrity of the investigation in the Reed case, the personal cell phone text, did not affect his performance of his police duties. And that the Mass State Police investigation into Michael was solely about personal cell phone messages and not about his job performance in the investigation. And that the charge of unsatisfactory performance of his duties is a misplaced charge. It's a charge that was designed as a Class A offense simply to appease the masses and fire Mike Proctor. In summary, Mike Proctor was a very good trooper, an exemplary trooper, a detective, who has been made to be a scapegoat as a result of the Mass State Police caving in to public pressure. Michael Proctor did not commit a crime. Michael Proctor did not violate any specific policy prohibiting personal conduct on a personal phone, because there is no specific policy. Those are two very important facts to remember in this case. Does his unprofessional conduct on his personal phone possibly warrant some discipline? Probably. Unbecoming conduct? Possibly. In October, we will demonstrate, when we have our discovery, that the termination of Mike Proctor, the firing of Michael Proctor to 12 exemplary years, does not comport with previous standards of discipline for the Mass State Police, and that is disproportionate with discipline meted out by the state police over the years. Michael Proctor should not be subject to the whims of politics or the whims of the media. He should obtain a fair hearing on the merits, and we expect to obtain that fair hearing through this process. No one should be unjustifiably pushed aside from his job simply because an organization wants to satisfy an agenda. And that's what happened here, folks. Thank you.
Issues of such a ruling that are request for sequestration order. I understand it's a long time from now to October 21st. I would be asking each witness in October if they have previously observed any part of this proceeding. If they're answering the affirmative, I reserve the right to take that into account in my fact finding. Also, any individual, however, who anticipates being called as a witness should not be watching today's proceedings.
May I?
Yes.
My only concern, Commissioner Carney, is that many of the witnesses on our pre-hearing list are not under our control. They're state employees, number one. So we don't have authority to tell them not to watch this proceeding. Number two, after we obtain discovery in mid-September, we may have additional witnesses who we just don't know about yet.
Right. As I just stated, I will ask each person before they testify.
Right.
And I'll take that into account. Thank you so much.
We're going to cherry pick through this.
Correct? Correct. First of all, you indicated on Monday that you're checked. Is that right?
Yes, sir.
You responded at 10:53 p.m. John O'Keefe. Is that right?
Yes, sir.
So you were willing to tell, just a few hours into an investigation of the death of an Austin police officer, you're willing to tell a bunch of high school buddies details about the investigation, including the name of the victim, correct?
I'll be back in a second.
Not a few.
16 is a few hours, correct? I'm not talking about days later.
There was about 16 hours later, sir.
Correct. And you identified John O'Keefe as the Boston police officer who is fallen in the yard at 34 Fairview, correct?
Correct.
You also informed, if you would skip to page 2529,
Thank you, Madam Commissioner. For the record, code 3 begins from our exhibit 6, video from June 12th, 2024, at about 0 hours, 38 minutes, and 20 seconds. For the record, that was paused at approximately 2 minutes and 30 seconds into this particular clip. Madam Clerk, or excuse me, Madam Commissioner, I apologize. Could you please, and my timestamps are based on full exhibit, so I am not to approximate. Would it be possible to add from 2 minutes and 33 seconds, would it be possible to add just under 10 minutes, 9 minutes and 53 seconds, so we can move forward to 12 minutes and 26 seconds.
correct?
Not that I was aware of.
Not a single bruise below the neck, right?
Not that I observed.
Looks a lot like a physical altercation, doesn't it?
Objection.
Sustained.
I'm back.
Bird writes, Bear, let's focus, correct?
Yes.
Who's Bear?
That's another nickname I have.
0095 writes, what does schmufflement mean? And then Bird writes, what's the story, correct?
Correct.
And you wrote, she hit him with her car. Is that right?
Yes.
For the record, this play, as I mentioned before, began at approximately 0 hours, 38 minutes, 20 seconds. It was played for approximately 2.5 minutes, then skipped ahead just under 10 minutes and played to the end of that particular clip, which would have been about 0 hours, 55 minutes, 12 seconds for exhibit 6. All right, sir. You just saw the 3 clips that I played, is that correct?
Yes.
The first 2 being Mike Proctor's sworn testimony under direct examination from prosecutor Adam Lowley, and the third cross-examination by defense attorney Alan Jackson.
Yes.
Is it fair to say that as to allegation categories A, B, and C, Mike Proctor's communications with other individuals on those text message chains continued with a series of messages exchanged with this system? Is that correct, sir?
It is.
Okay, yes, if you could have code 4, please. Madam Commissioner.
First message sent date time, December 10th, 2021 at 9:33 p.m. Last message sent 8:30, 2022 at 8:48 p.m.
At 8:30, that's August 30th, is that correct?
I'm sorry, yes, August 30th, 2022.
Similar to the other messages, is there an indication as far as how many number of messages were sent between yourself and your sister over that time period?
2,865.
And fair to say that the documents in front of you do not contain 2,865 messages?
Correct.
Now, just in reference to the first message on page 2662, the first page of this packet, you see that from December 10th, 2021 at approximately 9:33 p.m.
Yes.
And what does that indicate?
The text message for my sister. I called her earlier, told her earlier that I was puking in the background.
And you recall what that was in regard to?
From the sounds of it, I'm not going to have a sound.
Sir, if I could direct your attention to page 2667.
I don't even see why Michael Proctor trying to get his job back. Bro, you was done.
Correct.
You was like done.
Top of the page through the end, it please indicate to the jury as far as who's talking and who's saying what.
So I texted my sister at work, what's up? She responds, what? Why? I respond, I just found it frozen to death on our front lawn in Canton this morning. Actually just interviewed Jen McCabe, said she knows you.
If they know you, who are you referring to?
My sister.
And how did your sister respond?
Cut the shit. I responded to you. There's a technical correction with my response to you. She responded, yeah, she knows Jack very well. She's really good friends with Julie. My sister continues on. Her sister is married to Brian Albert. My sister asks, you still working? Question mark. I said, yep, gonna be on for a while. Homicide.
As far as your answers to those questions, or as far as your communications that you have with your sister at this time, the afternoon of January 29th, what were those in regard to, or why were you communicating that with your sister?
At that time, it was just kind of in the news. I was just kind of letting her know I was out working. Obviously, I didn't share anything specific. I didn't share anything specific on pieces of my family or anyone. It was just kind of an overall innocent conversation.
Turn your attention to the next page, 669. Again, you can read from that page as far as Fox 21.
My sister's it's off. The camping is a homicide. I respond. This is at 3 in the afternoon on the 29th. Don't say a word to anyone. She said, of course not. I respond, and at the very least it's suspicious. She responds, this is your livelihood. And I would never miss with that. 3:07, I respond, Julie and Chris were at the bottom with the victim and girlfriend. Got an interview now.
For the record, that was more extracted from exhibit for the video from June 10th of 2024, beginning at 6 hours, 5 minutes, 48 seconds approximately, and played till approximately 6 hours, 10 minutes, and 42 seconds. Detective Lieutenant Dwyer, in Michael Proctor's testimony about messages he sent with his sister relevant to allegations A, B, and C, did that testimony continue under cross-examination of June 12th,
counsel.
We've established that you're very close with your sister Courtney, correct?
Just for reference, we asked the commission to pause the video. There's a break in testimony. So it's that we asked for this particular clip, the commission to pause the video at 3 minutes and 57 seconds. It's approximately 2 seconds. 57 seconds. And advancing it 2 minutes, 9 seconds. Yes. Thank you for the
We've established that you're very close with your sister Courtney, correct?
Correct.
You provided your sister with updates on important advancements during the course of your investigation into this case. Did you not periodically?
I made her aware of newsworthy stuff.
That started as early as January 29th, 2022. Is that right?
Don't know the exact date or content.
Well, the date of the incident. Again, letting her know that you were involved, that you had been assigned, what the status was,
Yes.
the nature of the case, homicide, correct?
Yes.
I bet you discussed who the players were, who the people were that were involved. Is that right?
I just mentioned Julie and Chris were earlier in the evening.
So you mentioned the Alberts, correct?
Julie and Chris, yes.
You also mentioned the case, too.
Yes.
Yeah. At 2668, you want to that's the page I'm referring to. You're right. Homicide, correct?
So I said 2668.
Correct.
Okay, go ahead, sir.
You wrote the word homicide, is that right?
Yes.
You were describing to your sister the nature of the case that you are now assigned, is that right?
Correct.
She wrote the camp thing is a homicide, and you wrote don't say a word to anyone, correct?
Correct.
And then she wrote, of course not, is that right?
Yes.
And then you wrote what?
At the very least, it's suspicious.
At the very least, it's suspicious, correct?
Correct.
So at that time, it was at the time that you wrote that text on the 29th, at 3:05 in the afternoon, you believed the case was suspicious, right?
But before we found significant pieces of evidence.
So you believe it was suspicious that it may involve guns, right?
Absolutely not.
She then writes, this is your livelihood, didn't she?
She did.
Meaning, this kind of case could make or could break your career, right?
Objection.
She then wrote, I would never mess with that. Is that right?
Yes.
Your sister, Trooper Proctor, was warning you that you shouldn't be investigating a case in which close friends or family members were involved. Did you take her text? This is your livelihood. I would never mess with that. As a warning from her that you shouldn't be investigating a case that involved close friends.
Objection. Absolutely not. That was in response to don't say a word to anyone. And that was how I interpreted this. Your livelihood, I would never mess with that.
A couple minutes later, 3:07 on January 29th, you told your sister, quote, Julie and Chris were at the bar with the victim and the girlfriend. Gotta interview them. Is that right?
Yes.
So you were telling Courtney, your sister, updates on what your investigation advancements were, correct?
Just that part.
Interview, why you can interview them.
Yes.
She wrote, you gotta be kidding me, correct?
Correct.
Did
Oh, did they go lunch right there?
Let me ask you a question.
Okay,
Did you
never
ever
mind.
look for naked photos of a male suspect that you were investigating?
I don't look for naked photos of anyone's phones.
But you said you were looking for nudes of Miss Reed.
Like I said, Mr. Jackson, it was an inappropriate joke.
So this is a citizen. She's a woman. You were supposed to be objectively investigating. Does your text message to your colleagues and Massachusetts State Police reflect an objective investigation of a citizen?
Jackson.
You can get part of that question and ask again.
Do you believe that your text messages were reflective of an objective investigator?
Jackson.
I'll allow that. Do you believe that?
I believe the more jokes have unprofessional language and no bearing on the integrity, the facts, and physical evidence of this case.
It's not that they don't have any bearing on the facts and integrity, it's that they have no place in a professional investigation because it shows bias, right?
Jackson.
Sorry not to sustain that as next. Go ahead and ask it differently, Mr. Jackson.
You weren't so much as objectively investigating Karen Reed as objectifying her, correct?
Jackson.
I'll allow that.
Is that right?
Refrain.
All right, sir, I want to take you through the next few exhibits in attachment with the Department of Police. I'll be referencing specifically exhibits 12 through 18 that next group of questions. Several times just now, I asked you about the interview with July 24 hearing in this case of the department. Is that right?
Yes.
Did you have occasion to issue what's known as a standard subject call-in letter to Michael Proctor to arrange for that interview through his counsel?
Yes.
And did you ultimately make that initial call-in letter attached with Exhibit 12 to your report?
I did.
And go to Exhibit 12, respondents of Exhibit 12. Is that the same Exhibit 12 was attached?
Yes.
All right. And was that call-in interview date rescheduled in this case from that date to July 19th of 2024?
It was.
At the request of Mr. Proctor.
Yes.
And it did actually ultimately end up taking place on the date requested by the citizen.
Yes.
And was a second subject call-in letter issued as a result of the reschedule?
Yes. Yes.
And did you ultimately make that Exhibit 13?
I did.
All right, and that's the same Exhibit 13 as the earlier respondents 13?
Yes.
Did you provide to Michael Proctor prior to beginning that interview standard department administrative rights notice and waiver forms for purposes of conducting that interview on July 19th?
I did.
Were Michael Proctor and his counsel given full opportunity to read and execute those forms prior to beginning the interview?
Yes.
And were those forms constituting a total of 3 pages, ultimately made Exhibit 14?
Yes.
And is that the same Exhibit 14 response?
No.
All right, so what do you have there?
This is an email to True Proctor advising of his call letter.
Could I inquire, Commissioner, if it's possible that there was a printing error with regard to this binder? Thank you.
Could I inquire of the Commission with respect to, there appears to be a printing error with regard to Exhibit 14, and I apologize to the Commission. Is there a way to refer to the Exhibit 14 in the Commission's copy? All right, sir. My apologies for the confusion. Exhibit 14. The Exhibit 14 that's now before you is Respondents Exhibits 401, pages 401, 402, 403 and 404, are those the administrative rights and waiver forms that were executed by Mr. Proctor, counsel, on that occasion?
Yes.
My apologies.
The interview of Mike Proctor on that day, was that taken in the presence of counsel?
Yes.
And was he afforded, he being Mr. Proctor, afforded the opportunity to consult with his attorney as much as desired before answering questions?
He was.
Was the interview recorded?
Yes.
How was it recorded?
On a digital handheld device.
And I'll note for the record that that's been submitted as Exhibit 15 to the Commission. Detective Lieutenant Dwyer, ultimately, just to round out this particular series of exhibits in this portion of your report and respondents to exhibits, did you ultimately put what's known as a concise history, which is essentially disciplinary history for Michael Proctor? 16 to your report?
I did.
All right, and I'll look for the record of exhibit 16 from the system.
Come on.
Is the transcript of the testimony by Michael Proctor during that interview, and 70. Sir, and I think we've referenced it before, but just to be absolutely clear on the record, respondent to exhibit 18 is your report from author.
It is.
All right, so moving ahead, if I could please, the next set of exhibits. I have a series of questions on exhibits number 19 through 29, respondents 19. During the course of your investigation, were you permitted on the execution of the non-disclosure agreement that you mentioned earlier from the Federal District Court of Massachusetts to obtain and use for this disciplinary investigation copies of the trial exhibits from the Commonwealth versus Hearing prosecution containing text message chains that have been referenced?
Yes.
All right. And if you could please refer to exhibits 19, 20, 21. If you could just briefly take a look at 19, 20, 21 as in binder 40. And just tell me if those are correct representations of trial exhibits that contain the motives of this report.
Yes, sir.
Now, I'd like to ask you a couple of questions about exhibits 22 and 23. You turn to 22, please, sir. Respond.
I'll be right back. I'll let this play.
Could you just briefly describe for me, please, what is exhibit 22?
It is a training bulletin that's sent out to all members of the Mass State Police.
All right, and specifically, this particular training bulletin contained in respondents 22 is training bulletin 2017-19.
Correct.
Does that title for that training bulletin indicate it was issued in the year 2017?
Yes.
All right, and the title of the particular training bulletin is use of communication devices?
Correct.
All right, and just for completion here, is Exhibit 23 second issuance of that training bulletin for the 2018 date?
It is.
And is that the content of those essentially identical?
They are.
All right. Are these documents examples of notifications put out by the department to all employees, alerting them to specific legal policy and other developments as they arise?
Yes.
The two bulletins here together, exhibits 22 and 23, do they inform sworn members of an occasion which is for order production of law enforcement officers' personal smartphones in order to extract discoverable information from them?
Yes.
And specifically discoverable sources by law enforcement contained on personal cell phones in connection with the criminal case.
Yes.
Do they further indicate that that was done because officers had been communicating and therefore making statements about an official investigation on a personal smartphone?
Yes, sir.
In other words, the department was bringing to its employees' attention, specifically directed to members involved in criminal investigations and prosecutions, the discoverability of statements by law enforcement in the form of communications on personal electronic devices.
Correct.
If you could now refer, sir, to exhibits 24 through 26. 26. Sorry, sir. Are you at exhibit 24?
Yes, sir.
Is that a copy of Article 5 with an effective date of December 6th of 2023?
It is.
And Article 5 is one of the department's rules and regulations, specifically its rules of conduct applicable to all sworn members.
It is.
All right, sir. And with respect to exhibit 25, is that also known as Department Rules and Regulations Article 6?
Yes.
Specifically with respect to Article. Specifically with respect to Exhibit 25, Article 6, this is titled Regulations Establishing Disciplinary Procedures and Temporary Relief from Duty.
Correct.
And these are also applicable to all the sworn members of the department as of the effective date of this policy, September 27, 2023.
Yes, sir.
And finally, sir, Exhibit 26, is that known as Schedule A, Appendix A, stating the disciplinary guidelines for the department effective as of September 27, 2023?
It is.
And with respect to the specific charges and specifications that came about as a result of the findings of your investigation, can those be found in the internal charge sheet for Mr. Proctor's trial board and the accompanying charge summary?
Yes, sir.
Can you go to Exhibit 27, please, sir? So we responded 673, 674, is that correct?
Yes, sir.
Is that appear to be the chart sheet for Trooper Michael Proctor, then Trooper Michael Proctor, for IAS 2024-0014, in other words, your investigation?
Yes.
Madam Commissioner, at this time, I'd like to ask Detective Lieutenant Flyer a series of questions regarding exhibit, the response exhibit 35, and specifically the 3 clips that I provided to the commission. So I just wanted to ask for clips A, B, and C to queue up if possible. Thank you.
So the papers in their entirety.
They will be played in their entirety. They're just
less than 5 minutes. If it's the commission's inclination, I suggest playing through those clips and then bringing the lunch if that's
It's
acceptable.
okay, we do one then question and then one, because I'm not 1 o'clock.
Thank you. I will be sure again before. Before we play clip A from Exhibit 35, Detective Lieutenant Ward, if I could just ask you, sir. Following the termination of the appellant from the department, did you have occasion to learn of public interviews that he provided to news outlets that were broadcast this year?
Yes.
Was one of them the ABC News program?
Yes.
And did that air on June 17th?
I believe so.
Okay. With respect to this particular news interview that was broadcast at that time, Exhibit 35 for the record, this took place after the report was concluded, after the trial board was concluded, and after Mr. Proctor was terminated. Is that right?
Correct.
There is no sense in which any of this, because it post-states those events, there's no sense in which any of this directly led to or was part of the disciplinary process that started with the investigation. Is that correct?
Correct.
These are simply statements by the appellant made publicly after his termination was issued.
Correct.
Was your attention, prior to your testimony here today, sir, was your attention directed to that interview and a series of particular statements made by the appellant during that?
It was.
And did you have occasion to review those portions of that interview prior to your testimony?
I did.
May I ask, please, that clip A.
The murder mystery just outside of Boston sparking some explosive accusations against law enforcement.
Do you think Proctor will testify?
I don't believe so.
The lead investigator in this case, Michael Proctor, did not take the stand this time around. His highly offensive text messages about Karen Reed, which were obtained from his personal cell phone during a federal investigation, they blocked that first trial.
She's a whack job. Yeah, she's a maid. The way Fall River accent though, no ass. No good so far. She's gross.
During the retrial, the defense once again accuses him of running a biased investigation.
You'll learn there's not a single part of this case, folks. Not a
And you know what? I had enough of this. I don't see how people sat through 7 hours of the Michael Proctor thing. This is my first and last time talking about it. Now, if somebody wants to recap it.
single part.
Me personally, I ain't gonna do it anymore. Peace.